Good evening, everyone. Welcome. I am so glad that you're here to join us for this evening's presentation on legacy planning. And hopefully by the end of this evening, you will have gone away with a few hints and maybe we will have answered a few questions for you. I'm Pam Davee. I am Friends of the Columbia Gorges Director of Philanthropy. And tonight we have two very special speakers. We have our own Kevin Gorman, our Executive Director, along with Melissa May from Duffy Keckle, who is an estate attorney who is our guest speaker tonight to share her knowledge and expertise with us on planned giving. But before we start, I want to honor the Indigenous people who live in the Gorge and have lived in the Gorge since time immemorial. And before they were forcefully removed and relocated by settler colonization and the United States government. Through the treaties of 1855 between tribes and the United States government, the Warm Springs, Yakima, Nez Perce, and Umatilla retained rights to these lands that exist to this day. The United States was given the right to live on this land and govern these lands if we honor and uphold these treaties. Tribal people have greatly influenced gorge preservation and still do today as leading conservationists and the original caretakers of the land. Now I'd like to move on to just a little bit of housekeeping. Now I know everybody has been to a million Zoom meetings, but I want to remind you that if you have a question, we'd love for you to type it into the chat. And when you look at the chat where Elizabeth's remarks are, good evening, thanks for joining us, we'll begin promptly at 5:30, you have a place where you can go to all panelists and attendees down at the bottom, or just the panelists. So if you don't want your name to show up, hit all panelists and I'll see that and share it with Melissa. Now, Melissa will be answering questions, pausing throughout so that when we get to a topic that you might have a question on, she'll go ahead and answer it for us. And then we're also going to have a Q&A at the end with Kevin and Melissa. And then finally, I'm going to wrap it up with sharing some tools that you will be able to use as you're going through your planning process. I'm trying to think of anything else, but I think that does it. So what I'd like to do now is introduce you to Kevin Gorman, our executive director, who's been with the organization for almost 23 years now. So he has firsthand experience with how legacy giving has had just a huge impact on Friends. And he has wonderful stories to share. So I know you're going to enjoy them. So I'd just like to turn it over to Kevin now. Kevin?
Thanks, Pam. And I'm sorry, my video just for some reason takes a few seconds to come on. You're going to see me shortly. There I am. All right. Well, hey, everybody. Great to have you in our COVID world. Hopefully this is virtual meetings will become less and less as we move into the next year. I'd like to just take a few minutes before we get into the nuts and bolts with Melissa to talk a little bit about planned giving and bequest and what it's meant for this organization. So I'm going to share my screen quickly here, and we will have a little bit of a discussion about planned giving. This is from one of the properties our land trust purchased several years ago called Mount Oka, looking over at the Lyle Cherry Orchard in the town of Lyle. And again, the Lyle Cherry Orchard is also one of our land trust properties. Planned giving has just permeated through every aspect of this organization and the work we do. And I want to give you a little bit of the numbers here. We have had over the past 28 years about 48 bequests that have come into this organization. And when we look at what are really considered extraordinary bequests, it's usually the number 500,000 and above. And then under that is what are also very large bequest, but what is kind of more standard within the industry. And so we've only had a handful that have been above that big number, but about 90% of our bequest kind of fall into 500,000 and less. Now, when you think of the 80-20 rule, that 80% of your money revenue comes from 20% of your customers, it's kind of the same with our bequest world, that that 10% that gave 500 and above have given a tremendous amount to the total number of bequests we've received. It's been about 11.7 million that we've had come in bequest, and 9 million's come from a handful, but we still have also had 2.5 million from a significant number of folks. Now, the other thing about bequest, which has really also been really helpful for us, is that about 10% of them have been restricted, 90% have been unrestricted. And I will show with you shortly what that means. When the funding is unrestricted, it really gives the organization the chance to get creative and potentially bold and do things that it might not otherwise be able to do. So the fact that so much has been unrestricted has been helpful. And this is something I think that a lot of people might not really appreciate, that out of all the bequests we receive, about 75% of them were unknown. We didn't know they were coming in, and a quarter of them were. So essentially, for every one gift we've received, there are 3 that we also received, but we didn't know that we were going to receive them. So the fact that unknown gifts come in, that they're unrestricted, all of that has really been beneficial to this organization over the years. So I want to just talk about a handful of folks who really have made a difference for us. This is Norman Yan. Norman's father, John Yan, was the roadmaster of the Columbia River Historic Highway. He built the road essentially. And his older brother, John, also named John, was the gentleman who recruited our founder, Nancy Russell, to create our organization. Norman lived in San Francisco after growing up in Oregon, and he left a significant amount of his money, $4.5 million, to the organization as an unrestricted gift. And because of that, there was no restrictions on it. We at the time were looking at whether or not we should start a land trust. This is our original trustees. And in the white pants front and center is our founder, Nancy Russell. She owned a number of properties and really was pushing that we start a land trust. Well, Norman's gift allowed us to really do that. With that land trust, one of the first things we did was took on purchasing what we called the Cleveland property, which is up at Cape Horn, and removed this massive house, deconstructed this sort of porch and gazebo, and ended up creating the Nancy Russell Overlook, which is really one of the signature viewpoints today in the entire Columbia Gorge. Again, all of this happened because Norman left a sizable but unrestricted gift that allowed us the flexibility to move in this direction. With the land trust, we were able, in the money that Norman left us, we also were able to buy some of our first property. So Dancing Rock out in the East Gorge, a place called Cedar Falls, which is now Forest Service land, and then Carson Cove, which we still hold. All of these were purchases that were made as the result of bequest. Because of Norman's gift, we also hired our first Portland conservation organizer and allowed us to really start mobilizing people for issues that were coming down the line, particularly the oil and coal rail issues. That work couldn't have happened without bequest. Just a couple other things that bequest have done is that it seeded our endowment, and it helped us grow that endowment over 28-fold to what it is today. We were able to invest more heavily in a new website, social media, member database. A couple examples, we were able to hire some of the top attorneys and lobbyists whether it was fighting coal or oil issues or other issues in the gorge. I think if you sat back and tried to think about what are the aspects about Friends that you appreciate most, what are the things we have done that you have really felt good about, almost undoubtedly bequests have played some role in that because they have been so important to every part of our work. Real quickly, of course, our founder, Nancy Russell, left us, her large bequest was really in land. She left us land that she had bought over the years. She left us some deconstruction money for some of the houses that had buildings. And then she was not a fan, interestingly enough, of endowments. So she left us a gift that had to go to general operating support, which is kind of a classic Nancy thing to do, but we greatly appreciated it. Another gentleman here, Tom Holman, really a wonderful guy. He made the decision to give to the endowment. So he gave a $50,000 gift to our land trust endowment. So he wanted to make sure that it stayed on in perpetuity. And then finally, one of my favorite people in the world, Russ Jolly. This is Russ and I measuring the circumference of what we call the Jolly Giant, which is a 9.5-foot Douglas fir in the Lost Creek area that Russ had discovered. And Russ was never a man of means. He always lived on very little. And when he died, he left his entire estate to us. And it was a total of $40,000. And it really was one of the most heartfelt gifts that I think we've ever received. Even though it wasn't as big as some of the others, it was really symbolic of his life and who he was. And it meant a lot to us. And we were able to put it to good use immediately. So these are some of the characters, some of the people that have been involved, and I'm happy to answer more, but I'll leave you with this before I pass on to Melissa May. You know, Pam, if you've talked to Pam about planned gifts, we often keep track of who has been committed and said, yes, I'm leaving you in my will, and who in fact is listed as interested, who say, yes, we're interested and we may get to it, we hope to get to it, but our life's complicated. And for years, my wife and I have lived in the interested category. Of course, we wanted to leave money in our will to friends, but at the same time, we had a young daughter. We had a lot of other things going on. And so it's just been slow. Well, our daughter's now a senior, or going to be a senior in college next fall. And we finally have gotten around to doing our will and putting a portion of our estate in for Friends of the Columbia Gorge. So we, among all people, understand that it takes time, that your life, you need to get in order, and we're all doing it. And but I just want to appreciate and acknowledge the folks who have come on this call to learn more. And so with that, I think I will introduce Melissa. It is wonderful that she is giving us her time today. Melissa is a estate planning attorney with Duffy Keckle, which is a law firm we've worked with for a number of years. One of their attorneys helped us over 2.5 years to navigate that Normannian estate, in fact. And Melissa advises clients regarding tax-efficient transfers of assets to their family members and other beneficiaries. Her practice focuses on estate planning and administration of estates and trusts. Her practice includes preparation of revocable trust agreements, wills, life insurance trust, gift trust, and other irrevocable trust, as well as assistance with the administration of descendants' estates and various types of trust. Melissa graduated from Auburn University and Washington and Lee University School of Law. And after practicing on the East Coast for several years, she moved to Portland and has been a proud Oregonian since 2012. So with that, I will hand it off to Melissa.
Thank you, Kevin. See if I can get my video going. There we are. Hello, everyone. I'm glad you could join us this evening. I'm going to share a few slides to just keep us on track here as I talk a bit about estate planning with a bit of a focus on charitable planning and the ways that you can help your favorite organizations while also planning for yourself and your family. Let's see. All right, there we go. So here's what we're going to talk about tonight, just a quick overview. What is estate planning? What is an estate plan? And how do you create one for yourself? I'm going to talk a little bit about estate and gift tax because there's some interplay there between the estate and gift tax that you or your estate might be subject to and some of the tax benefits that you can get through charitable giving, both during your lifetime and at the time that you pass away. So what's an estate plan? You have an estate plan, even if you've never signed a will or seen a trust agreement or given it a second thought. Everyone has an estate plan. And the first element of your estate plan is how you hold your property. The way that your property is titled can affect how it passes at the time that you pass away. And so, of course, if you have property that you own jointly with a spouse or with anyone else, and you have rights of survivorship in that property, then the surviving joint owner will automatically inherit and own and control that property when the first joint owner passes away. The other piece of estate planning that you probably already have in place, whether you meant to or not, is beneficiary designations and automatic transfers at death of other types of assets. So your retirement plan accounts, your IRAs, 401ks, hopefully you have filed a beneficiary designation with the custodian of those accounts, likely naming a spouse or your children or a charitable organization as beneficiary. Even if you haven't, even if you never got around to filling out that form, the plan has designated a beneficiary for you. That beneficiary might be your probate estate or your spouse or your heirs at law, and we'll talk about what that means. So that's another element of an estate plan that you already have in place, even if you've never signed a will. And then, of course, there's what people traditionally, classically think of as an estate plan. That's your will, if you have one. And if you, whether or not you have a will, you also might have a revocable trust. Revocable trust is what I think of as a will substitute. That is a document that you can create that states all of your wishes for how your property passes after you pass away and nominates people to be in charge of gathering up your assets, paying debts, and sending your assets to where they need to go. And the reason it can be used as a will substitute is if you take everything that you own and put it into the name of your trust while you're living, then when you pass away, there's no need for a will because the trustee of the trust will continue to manage and control and distribute those assets. And the thing that's nice for a lot of people about having a will substitute is simply avoiding the probate process. If you have a will and you own property in your own name that doesn't pass by the right of survivorship and doesn't have a beneficiary designation, whatever you own in your own name at the time that you pass away has to go through probate first before it can be distributed to your beneficiaries. And probate is not, it's not the end of the world. It can be a little bit expensive. It causes some delays that your trustee or personal representative might otherwise be able to avoid. But the concern that most people I speak with have about probate is not so much the expense and delay, it's really about privacy. Whatever you have that passes through probate when you pass away will be listed on an inventory, and that inventory will include a brief description of the property and its approximate value. And meanwhile, your will be a public record as along with that inventory as part of the probate court records. And so folks with younger children or complex assets or valuable assets, or just people who are more inclined to be private, will oftentimes prefer to avoid that whole process and choose to create and fund a trust during their lifetime. And then finally, even if you don't have any estate planning documents at all, no will, no trust, nothing like that, the state gives you an estate plan. And what the intestacy statutes say in most states, including Oregon, is that if you didn't leave a will and you own property at the time of your death that doesn't pass by beneficiary designation and doesn't pass to a surviving joint owner, then the probate court will take that property and distribute it to your next of kin. And there are very extensive definitions of who your next of kin are. And if all else fails, if you don't have any distant relatives or close relatives, then actually your property will escheat to the estate. To the state. And so that's a fancy word for saying the state of Oregon will own your property if all else fails. So a lot of the planning that I do with clients centers around tax planning, not so much income tax planning, although there is an element of that, but more so the concept of planning for wealth transfer taxes. Fortunately, a lot of us don't have to worry about the federal estate tax right now because our exemptions from that tax are at 11.7 million per person. So double that for a married couple. It's good that we have such a generous exemption because the rate is fairly high. It's a flat 40% on every dollar above 11.7 million. That exemption is a bit of a moving target. So go ahead and breathe a sigh of relief now if you are under 11 million or you and your spouse are under 23 million, but keep an eye on it because there are a lot of proposals floating around out there to reform the estate tax a bit and move that exemption amount back down to the amounts that were in place, 10 years or so ago. I think the latest proposal I read was for a $3 million exemption instead of 11.7. Layered on top of the federal estate tax is a federal gift tax. So you can't avoid the federal estate tax by giving everything away the week before you pass away. That 11.7 million exemption covers both gift transfers during lifetime and transfers at the time of your death. Now, here are some exceptions or the things that don't count towards your exemption. Anything you give to your spouse has an unlimited exemption from estate and gift tax. That's true at the federal level and at the state level as well. So as long as your spouse is a US citizen, you can give him or her as much as you want and not have to worry about paying gift taxes, estate taxes, anything like that. The other major exception to the federal estate and gift tax and the state estate taxes is your unlimited charitable exemption. So you can give as much to the Friends of the Columbia Gorge and your other favorite charities as you'd like without incurring any gift tax or estate tax at any level. Above and beyond that, whatever you give to someone who isn't your spouse or to someone who is not a tax-exempt charitable organization, that's what's subject to your $11.7 million exemption for federal estate and gift tax. We won't even talk about the federal generation skipping transfer tax. This comes into place when you have a gift or a bequest to a grandchild or someone who is further removed in your line of descendants. So it's just something to have in the back of your mind, maybe ask your attorney about when you're doing your estate plan. But federal estate tax aside, we also have to think about estate tax at the state level in Washington and Oregon. And you'll see on your screens there, the exemption amounts there, a little stingier than the federal exemption amount, although the rates are a good bit lower as well. So the state level estate taxes are not as much of a burden as the federal estate tax. It is worth, I think, doing some planning to do two things when it comes to the state level estate taxes. One is to potentially, two things. One, to make sure that if you are a married person, that both you and your spouse get to take advantage of your full exemption amount. So in Washington, that's 4 million and change for a married couple. And in Oregon, that's $2 million for a married couple. And the other thing to do is to think about, if you are, especially if you're hovering near, let's say you're an Oregon resident and you and your spouse have $2.1 million. It might be worthwhile to do a little bit of planning to go ahead and get your estate down below that tax filing threshold of $1 million. So let's say the first spouse passes away, preserves $1 million in trust for the benefit of the surviving spouse. And then the surviving spouse has in her own hands $1.1 million. Maybe she wants to go ahead and give away that $100,000 to dip below the estate tax filing threshold and be assured that no estate taxes will be due when she passes away. So you can do that by giving that amount away to individuals, that's fine. Or you can be really tax efficient and give that amount away to Friends of the Columbia Gorge or to another charitable organization. Important note, I won't dwell on it, but just something to think about. Unlike the federal system, the state estate tax systems do not have this gift tax layered on top of the estate tax. So you could give away an unlimited amount to anyone the day before you pass away, and that property is removed from your gross estate for estate tax purposes. And that's true for a Washington resident, and it's also true for an Oregon resident. It's not always the best idea, however, because anything that you give away to an individual during your lifetime, that individual takes your tax basis in that asset. And so that means when they turn around and sell it, if it had a very low basis in your hands, it has a very low basis in their hands, and they're paying all the capital gains tax on the sale of that property that you gifted to them. So from an income tax perspective, in the beneficiary's hands, a lot of times it's actually better to wait, hold the assets, pass away holding the assets so that your recipient gets a step up in basis to the value of the asset at the time that you pass away. And they turn around and sell it and have minimal or no capital gains tax owed. So it's sort of a balancing act between, are we exposed to state level estate tax? And if not, then easy enough, let's go ahead and hold on to this and get the basis adjustment at death. If you are, then you have a little bit of a balancing act. What's our estate tax rate effectively? What's the capital gains potentially in the hands of the beneficiary? And just sort of work through those numbers with your CPA and your attorney and decide sort of the timing of your gifts. So here's really the heart of what I wanted to talk about this evening, and that's charitable planning. And it's doing some good for your favorite organizations and in many cases, reaping some tax benefits for yourself at the same time. So as I mentioned earlier, you have an unlimited charitable deduction for estate tax purposes, for gift tax purposes, for state level estate tax purposes. And most of the types of gifts that you make during your lifetime also are eligible, eligible for income tax deductions. Now you're going to have limitations based on your income and the type of asset that you're giving it away and the type of recipient of that asset, but still you're likely to get some sort of income tax deduction for any lifetime giving that you do. And so I wanted to just, there's really an unlimited array of ways to give things away during your lifetime, but I wanted to focus on a couple of them. The probably nicest and relatively recent, or only relatively recently became permanent thing that you can do with your traditional IRAs is a charitable rollover, which is sort of the informal term for it. What it really is called a qualified charitable distribution. So let's say that you are age 72 or 72 and a half, and you have begun taking your minimum required distributions from your traditional IRAs, you can actually, rather than taking a distribution, you can divert up to $100,000 of your minimum required distribution directly to a charity, and that charity will receive those assets tax-free, of course. It counts towards your MRD, your minimum required distribution amount. And of course, you don't pay taxes on it because it went straight to charity. Now, you don't get to double dip. You don't get to send the charitable rollover to charity so that you don't have to recognize the income and then also take a charitable deduction on top of that, because your charitable deduction was sort of built in when you made the qualified charitable distribution. So that's a really nice tool for folks who find themselves in the unfortunate yet nice position of having such large minimum required distributions that they are paying unwanted taxes on money that they don't really need. And then, of course, for all of your other assets, the easiest type of charitable giving to do is just making an outright gift. Write a check to the Friends of the Columbia Gorge, set up a recurring donation with your favorite charity. There are also ways to give things away during your lifetime while still retaining a benefit. And so one that I know that the Friends of Columbia Gorge participates in is called a charitable gift annuity. And that's where you can give, let's say, some stock that has appreciated in value, or just some cash that you don't need. You give that money, put that in a charitable gift annuity, and Friends will pay you a stream of income that's based on the amount that you gave and your age, which is kind of nice to know that you have a little bit of a stream of guaranteed income coming in while you've also done some good for your favorite charitable organization. Similar concept, used more frequently for, I would say really for appreciated real property more than anything else, is the Charitable Remainder Trust. There are a couple of variations on the Charitable Remainder Trust, but that's another tool that's out there. If you have some assets with a low basis, maybe some real property that you've depreciated over the years, so that if you sold it next week, you would realize a pretty sizable capital gain and owe a bit more than a bit of capital gains taxes. A charitable remainder trust or one of these other planning techniques can be a good way to get yourself out from under that income tax bill and do a lot of good for the Friends of the Columbia Gorge. You also can do sort of the inverse of a charitable remainder trust. That's a charitable lead trust, and that's where you provide an income stream for charity from some asset that is generating income. And then after a period of years, whatever's left from that asset would then pass to your family members or your friends. Those are probably less common than charitable remainder trusts, but they are attractive to some people with the right asset or mix of assets. And then something that you've probably heard a lot about are donor advised funds. Maybe you have donor advised fund somewhere. A lot of the larger brokerage houses will have an arm, Fidelity Charitable Services or something like that. Our local favorite, Oregon Community Foundation, also sponsors donor advised funds. And the neat thing about donor advised funds is that you don't necessarily have to make a decision right away about how to direct your gifts. You can make a gift to a donor advised fund this year. It's treated as a public charity so that you get the maximum income tax charitable deduction available. And whatever you've put in that, of course, is out of your gross estate for federal and Washington or Oregon estate tax purposes. You get your deduction right away. You don't necessarily have to then turn around and redistribute that entire amount right away. You can take some time to do your research and think about special projects that you might want to sponsor. And then what you do is you make a recommendation to the custodian of your donor advised fund. So let's just say it's the Oregon Community Foundation. You tell OCF that you would like to distribute $50,000 from your donor advised fund to the Friends of the Columbia Gorge. And technically they don't have to do that. But technically they're the ones in control of the distributions from the donor advised fund. But in general, they're going to take your recommendation seriously and follow it and make the distributions that you request. The other nice thing about a donor advised fund is that, without all the bells and whistles and compliance headaches of a private foundation, it is a way to get your children or other family members involved in charitable giving. They can slide into your place as the advisors for the fund after you pass away, or just whenever you designate. So that's a nice way to carry on a family legacy of charitable giving. And then I just want to mention that conservation easements exist. They're pretty complex, but the basic idea is if you have a piece of land that you would like to see preserved from development, you can in fact grant a conservation easement to a charitable organization that guarantees that that land will not be developed. It won't turn into a golf course or a massive subdivision. And you'll also get a charitable deduction for making that gift of a conservation easement. So the last sort of final piece that I wanted to talk about for charitable giving is pretty important. Again, it saves you estate tax on both a federal and state level, and that is giving property, money, anything to charity at the time that you pass away. So you can incorporate charity into your estate plan just, as you go along. Maybe you want the bulk of your assets to pass to your grandchildren, but you want to say right off the top, the first 10,000, the first 50,000, first 2.5 million is going to pass to your favorite charities, and then everything else goes to your family. You can also do the reverse. You can say, I really feel like my property needs to go to taking care of my children first and foremost. And then if there's something left over, it can go to charity. Or you can say, if my family's been wiped out, then it can go to charity. There are different phases at which you can build charitable giving right into your estate planning documents, your will or your revocable trust. I also want to point out that those traditional IRAs, whether or not you participated in any charitable rollover or qualified charitable distributions during your lifetime, those traditional IRAs are a great source for making charitable gifts at the time that you pass away. And here's why. Every dollar in your traditional IRA or other traditional retirement accounts, not talking about Roths, just traditional ones, every dollar in there has to come out someday. If it comes out to you, then you're paying income tax on the distribution. If it comes out to your spouse after you've passed away, he or she is paying income tax on that distribution. And if it comes out to your children or other individuals, they're paying income taxes on those distributions. And now, under recent changes in the law, pretty much everyone except your spouse has a pretty limited window to pull those funds out of the IRA. It's now about 10 years after you pass away, which can mean, some pretty large distributions and some pretty large income tax hits on those distributions over, during that 10-year period. The nice thing about leaving your IRA or a portion of your IRA to charity is they'll pull those funds out, and of course they won't pay any income taxes at all. There's no income tax due when a charity receives an IRA or a piece of an IRA. Meanwhile, your friends and family members can benefit from your other assets under the rest of your estate plan. And when they receive those assets, they aren't paying income tax on, say, the interest in your home that they received, or the money in your bank account that they received. So it's sort of a win-win all around. If you want to include a charity in your estate plan, my favorite idea for almost everyone is to have that come right off the top of your IRA. You can designate a dollar amount, you can designate a percentage, or you could just send the whole account straight to Friends of the Columbia Gorge or your other favorite charities. And charity is happy because they get money. Your family's happy because they're not paying income taxes on what they've inherited from you. And you're happy because you know that you've done a good job of taking care of friends and family and your favorite charity while doing it in a tax efficient manner. So I think we probably have a few minutes if anyone has questions. I think I see someone ask a question in the chat. Yes, Pam pointed out that they partner with Oregon Community Foundation to work with charitable gift annuities and other more complex planning tools. That's great.
Absolutely. But we do have a couple of questions for you that I got ahead of time, and then and for you as well, Kevin. But one of the things that folks are wondering about is, how do you start working with an attorney like you, Melissa? What is the easiest way to get going on figuring out just how to start?
Sure. Most of us have tools to help people get started because we recognize that it can seem like a daunting task. So, if you know an estate planner, that's great. Get in touch. We'll fix you up with our tools to get started. If you don't, ask your friends and family, ask me. We have plenty of estate planners in my firm too. And what we usually do is just have a conversation about what your goals are. We'll usually send you just a couple page questionnaire to help you gather your information. And then we really get started with a pretty comprehensive meeting where we talk about what your options are and what the things that you need to think about are. And then you make your decisions, and we make nice drafts for you and help you get your asset titling and beneficiary designations set up so that you can accomplish your goals.
That's great. Well, speaking of beneficiary designations, we have a person who is wondering, do you need to go to an attorney to designate the beneficiary of your IRA or your insurance?
No,
Life
you
insurance.
don't. You do that directly with the custodian of the IRA or with the company that issued your life insurance policy. It is a good idea to send a copy to your attorney so that they have it in their records. And if you have a sort of complex estate plan where money going to charity over here ought to reduce the money coming to charity from this bucket over here, that bucket mostly being your trust, then you might want to check in, but you certainly don't have to. Most estate plans are set up to be sort of self-adjusting, and you certainly can do those adjustments yourself.
Great, thank you. Kevin, one of the questions is, well, and actually Melissa mentioned conservation easements, and how does Friends work with those?
Well, we really just have a couple of conservation easements, and actually several of them are more trail easements where somebody has agreed that either at that time or in the future, a trail could go through some portion of their property. So we have worked that out. Conservation easements, if we are just working to preserve land, it's always easier, less complicated to do it just through a straight up acquisition, and then we hold it, we manage it. But there are a number of conservation easements that are out in the gorge that the Forest Service owns, for example. A lot of the farmlands that are across from the Vista House that you look on the Washington side, those are under conservation easements to keep development from sitting right in the middle. So we would look at if somebody wanted to donate a conservation easement, but there's complications with it. And often what happens if someone donates a conservation easement, then they also donate resources to create a stewardship endowment to carry out and protect that conservation easement over the years, because it costs money to year after year continue to enforce that those conservation values stay in effect, even because you have landowners and new landowners and new landowners. So it's a process.
Yeah. All right. And then the last question we have for you, Melissa, is what do your clients like most about setting up a charitable gift annuity? The benefits of receiving that?
I think the thing that delights them the most is that they're helping out their favorite charity. Um, the people really do feel good about giving to their favorite charitable organizations. The other thing that's nice about it, in addition to sort of any capital gains tax savings that you achieve by doing that, the thing that's really nice about it is, most of us don't know how much we're going to need to live out the rest of our lives. We don't know what kind of long-term care we're going to need, what the economy will do, and so forth. And so there's definitely some personal comfort in knowing that you have a stream of income coming in from that source, no matter what happens to the rest of your assets and the rest of your investments. So I think it's both. It's a little bit of comfort having an income stream for yourself, and probably a little more importantly, that satisfaction of helping out your favorite charity.
That's wonderful. Thank you for letting us know about that. Now, since we've gotten through questions and the previous presentations, I just wanted to wrap us up with a few of the tools that that we have available that Melissa alluded to as something that can help you get going with your process. So let me share my screen here. Okay, is that working, folks? All right. Well, one of the first things is our website. The website is just a very valuable tool that's got some general information and in some cases some more specific information that is there for you to refer to regarding some of the things that Melissa was talking about, beneficiary designations, bequest language, that sort of thing. And it's also really easy to get to. You can go to gorgefriendslegacy.org, or you can go to our regular website in Ways to Give and Plan Giving. So there's a couple of ways to get to it, but this is a nice way to get going. And then there's also information on the website about a variety of information that we get through the organization that we work with that helps us keep us abreast of different things that are happening in Plan Giving, and that company is called Crescendo. So you'll see a little bit more about that there too. Also, Handy Dandy Will's Guide. This is one of these tools that we find has helped so many of our folks because it really helps you get your thoughts organized, whether you're talking to your CPA or your state attorney or just starting the process going. This guide helps you through that with the who and the why and the what and that sort of thing to get you get the creative juices and the organizational juices flowing. And this you can get by downloading it from the website that I just mentioned, or just call me or email me and I will send one to you. And then when you put friends in your will or your estate plan, I should say, you become a member of the Norman Yan Legacy Circle. And Kevin told you the story of Norman Yan. He's very near and dear to our hearts with this organization, not so much because of the size of the gift, but because of his vision. And that vision enabled friends to do so many different things. This was beyond his lifetime. And it was one of these things that has made a huge difference to an organization. We have so many people that are in the legacy circle now. We actually have just over 200. So it's a small group within a membership of 6,000. But this is something that they take very seriously. We take very seriously. And not only do we take it seriously and appreciate it, we celebrate. And one of the ways that we celebrate is gathering. And for the past several years, we were able to get together on aboard the Columbia Gorge Sternwheeler. Unfortunately, due to the pandemic, whose name shall not be mentioned, we weren't able to do it last year. But this year, we have a date. We have August 8th, 2021, where we'll be getting together aboard the ship. And it's lovely because you get to be out on the river, seeing the gorge from the river instead of vice versa. and celebrating and rubbing elbows potentially with people with like-minded views on how they want to protect the gorge. Plus, you'll get to meet with staff and board, and it's a champagne brunch that it is our way of saying thank you. So this is just sort of a fun and nice way to get together and celebrate all of our love of the gorge. And speaking of thank you, we really appreciate you being here tonight. Hope you've learned a few things, and please do not hesitate to contact us if you have any further questions. With that, I'll say have a great evening and happy Earth Day.